You're listening to the Patenting for Inventors podcast with registered patent attorney, Dr. Adam Diamond, founder of Diamond Patent Law, the #1 source for securing your intellectual property needs. Now, here's your host, Adam Diamond.
Hello and welcome to the Patenting for Inventors podcast, episode 92. No foreign filing license? Go to jail. My name is Adam Diamond, a registered patent attorney and founder and owner of Diamond Patent Law in Los Angeles, California. I can be contacted through my website at diamondpatentlaw.com. That's D-I-A-M-E-N-T, patentlaw.com, or call me at 424-281-0162. Here's the situation. You're an inventor in the United States. You have an invention, and you came up with it in the United States, but you don't think it'll actually sell well in the U.S. It would only sell well in Mexico. So you find a Mexican patent attorney and ask her to file a Mexican patent application for you. Can you do it? Actually, no. It's illegal to do that, and you could be fined no more than $10,000 and imprisoned for not more than 2 years, or both. Now, it sounds really harsh. You're only allowed to file in foreign countries if you have a foreign filing license. The good news is that it's super easy to get. Now, why does the U.S. government even care if you file in another country? Basically, they don't want any technology created or thought of in the U.S. to be exported to other countries in case there's some type of national security issue. So how do you get a foreign filing license? The easiest way is to file either a provisional or non-provisional patent application. And when you get your official filing receipt, the receipt will say foreign filing license granted. As long as your invention isn't some kind of nuclear weapon or military arms patent or some other implement of war, then you should get it. If for some reason you don't receive an explicit foreign filing license, but 6 months have passed, and you don't explicitly receive something saying that you're not allowed to foreign file, that would be called a secrecy order, then you can foreign file. So in theory, on the books, you can have a $10,000 fine, 2 years in jail, or both. But my guess is that this is kind of a severe punishment. It would be reserved for someone exporting nuclear weapon technology to North Korea or something like that. I can't imagine two prisoners talking and one of them saying, what are you in for? Murder. What are you in for? I filed a patent application in Canada for a baby pacifier without getting permission from the U.S. Patent Office. But in the scenario that I talked about, someone doesn't even want to file in the U.S. at all. Does that mean that they have to file in the U.S. just to get a foreign filing license? And the answer is no, because there is another way. You can fax a request for a foreign filing license with a copy of what you intend to file in that foreign country. And the Patent Office should review it, and in a few days should issue you a foreign filing license. Now, if you forget and file anyways, you can petition for a retroactive license and say the countries that you applied in and that you made a mistake and you pay a fee, and you should get a retroactive license and you should be fine. I would say it's pretty rare that a U.S. applicant isn't going to want to file in the U.S. first, but it might happen, and just be aware of what you have to do beforehand. Now, another common scenario might be that a person wants to file a PCT application. If you remember from my PCT episodes, you can file a PCT application in lots of countries. If you're in the U.S., you usually have a choice of only filing in the U.S. receiving office or in the International Bureau, which is in Switzerland. Now, just be aware that unless you filed a provisional patent application, and then got a foreign or a non-provisional, and then got a foreign filing license, you probably should file in the U.S. receiving office. And that's because if you file in the International Bureau, it's also considered a foreign export. And the next question you might have might be the opposite. There are lots of people in foreign countries that don't care about getting a patent in their own country, but they really want a patent in the United States. Are they allowed to file in the U.S.? And the answer is yes or no. Legally, they can file in the U.S., and the U.S. will grant a patent no matter where you're from. The question is going to be whether the country that they're from has some rule like in the U.S. where they're not allowed to foreign file without a license from their own country. And maybe they could be fined or put in jail if they file a U.S. application without a license in their own country. It really depends on the country and what rules they have. In China, you have to receive clearance to file in other countries. In Russia, you have to file an application in Russia before filing abroad. In Indonesia, there are no restrictions. There's a table on the WIPO website that lists all the countries having rules about what the inventors are allowed to do for foreign filing. So search for WIPO, that's W-I-P-O, that's World Intellectual Property Organization, foreign filing requirements. You should get to a page that has a table with all that kind of stuff. Now, you can get into tricky situations where maybe one inventor is in Russia, one is in the US, or some other joint inventor rule where the inventors are in different countries. where are you allowed to file? What do you have to do? You should really consult a patent attorney if you have a tricky situation like that, or any situation where the inventors are trying to file in a country not of their own, where they're not a resident or citizen. Sometimes it's very simple and they're allowed to do it, but other times they might not be allowed to. If you want help with your patent application, trademarks, copyrights, responding to rejections, appeals, or anything else related to your invention, you can contact me directly through my website at diamondpatentlaw.com. That's DIAMENT, patentlaw.com. Email me at adam@diamondpatentlaw.com or call me at 424-281-0162. I'm Adam Diamond, and until next time, keep on inventing.
Thanks for listening to the Patenting for Inventors podcast with host Adam Diamond. If you enjoyed the show, please rate and review on iTunes. The contents of this podcast are intended for general informational purposes only. The facts of every legal matter are unique, and the content of this podcast should not be construed as offering legal advice for your specific legal situation. For more information and help with your own intellectual property needs, contact Adam Diamond at patentingforinventors.com. That's patentingforinventors.com. or call Diamond Patent Law at 424-281-0162. The preceding information may be considered an attorney advertisement and does not establish any attorney-client relationship.